Good morning to everyone at today's meeting of the public hearing of the Prosecutor Vetting Commission. My name is Christopher Lehman, chairperson of the commission, and I declare this session to be open. Our commission is established under Law 252 on the external evaluation of judges and prosecutors. Under Article 22, paragraph 13 of that law, it provides that the commission will assess candidates for the Superior Council of Prosecutors Selection and Evaluation Board, according to the procedures and criteria regulated by Law 26 of 2022 on measures related to the selection of candidates for the position of members in the self-administration bodies of the prosecutors. The hearing is also being conducted under the Commission's Rules of Procedures for Evaluations under Law 26, 2022. The subject of today's hearing is Ina Fencovschi, a candidate for the Superior Council of Prosecutors Selection and Evaluation Board. Ms. Fencovschi, welcome to the hearing this morning. I am joined by my colleagues on the commission. From my far right, Nadezhda Hryptievsky, Ermontis Mikalonis. To my immediate right, the commission vice chair, Virginia Mararu. To my far left, Cornel Lebedinsky, and to my immediate left, Saskia DeVries. The commission is also assisted by members of our secretariat. This hearing is open to the public and members of the media. The hearing will be conducted with interpretation into English and Romanian. I would ask the Ms. Fencovschi to speak clearly and slowly when she answers questions for the benefit of the interpretation. The proceedings are being recorded. The recordings of the Commission's public hearings will be available online on the Commission's website within 3 days after the hearing. Ms. Fencovschi, during the hearing, one or more members of the Commission will ask questions to you. Please answer them truthfully and completely. Your explanations are important to the Commission in the evaluation of your financial and ethical integrity. In formulating our questions, we'll take into account your privacy and, where required and possible, the privacy of your family members and close persons. We'll leave out any unnecessary details with regards to ID numbers, bank account numbers, the specific addresses of real estate, and so forth. For the protection of your privacy, we would ask that you do the same in answering questions. At the end of the hearing, you'll be given an opportunity to make a brief closing statement. I'll start by briefly reviewing the evaluation process for Ina Fencovschi. The Commission initiated its evaluation on the 22nd of December 2023 by notifying her by email and asking her to complete and return both the ethics questionnaire and the 5-year declaration. Ms. Fencovschi did return those completed questionnaire and declarations on the 29th of December 2023. As part of the evaluation of a candidate's ethical and financial integrity, the Commission also obtains information from many other sources. Those include the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, and so forth, as well as other public institutions, financial institutions, and open source information. The Commission assesses the information it obtains from these sources for relevance and reliability. The Commission sent you 5 rounds of questions. Those were on the 15th of July, 2024, the 30th of September, the 16th of October, the 24th of October, and the 12th of November of this year. You responded to all of those. On the 18th of November, 2024, the Commission invited you to attend today's public hearing. At that time, we notified you of the specific topics that would be addressed at the hearing. Ms. Fencovschi, thank you again for appearing today. I'll begin with just a few questions to you. I ask you to respond in a complete and truthful manner to all questions. My first question is whether you wish to make any additions or corrections to answers that you have provided previously to the Commission in our request for information.
Hello, esteemed members. No, nothing to add.
And I just want to ask if the answers that you provided in your 5-year declaration and your ethics questionnaire that you returned on the 29th of December 2023, Are those answers all still accurate as of today?
Yes, they are correct and valid as of today.
Thank you. At this point, I am going to yield the floor to my colleague, Virginia Marraro, the Vice Chair of the Commission, who will have additional questions for you.
Thank you so much, Chris.
Welcome, Ms. Fencovschi, to today's hearing. At this hearing, we are going to address the topics that were included in the invitation we sent you to take part in the planned hearing. Also, these topics were raised in the rounds of written communication with the Commission, so that will not be something new. I want you to be correctly perceiving and being aware that this communication, both written communication and today's hearing, is not about accusing you. We just want to establish all the circumstances in order to see if the Commission keeps any doubts about your financial and ethical integrity, or the doubts are mitigated so that we would be able to issue a final decision. When you answer the questions, I'd like to ask you to speak loudly and clearly so that it would be easier for our interpreters to translate for our international colleagues. The first topic is discrepancies between the purchase price and declared price in the annual declarations of assets and personal interests for the cars Land Rover Discovery and Toyota Auris, as well as the reduced purchase price declared in the annual declarations for the Land Rover car. In December 2015, your husband purchased a Land Rover Discovery car, manufacturing year 2006. In the annual declaration of income and property for 2015, in the heading value of the asset according to the document certifying its provenance, you did not mention any amount of value. And in the annual declaration for the assets and personal interests for the next year, 2016, you mentioned that the value is not valued. So this is retrieved from your declarations. Also, in the subsequent annual declarations of personal assets and personal interests for 2017 to 2022 for the Land Rover Discovery car, you reported the amount around 100,000 lei. That would be an estimated 4,650 euros, except for the annual declaration for 2020, when this property was not reported. Please confirm or deny this. I would like to clarify that car indeed was purchased by my husband. It was purchased, if I'm not mistaken, in November 2015, and it had to be declared in the next year, in 2016. Indeed, in 2016, I did not declare it. I mean, I declared it as a means of transport in the declaration of income, but I did not report its price. Because when I was filling out the declaration, I had the sale purchase contract where I saw that the price was not real, so to say. In the sale purchase contract, the price mentioned was 10,000 lei, and I understood that the car, and I knew exactly that it couldn't have such a price. Therefore, in order not to write some amounts that from the very beginning are wrongful, I preferred not to write the amount of that car. That's why I focused on declaring the vehicle, and since I did not have clarity about the price, I did not report the price. And then later, starting in 2017 to 2021, that car was declared with a price of 100,000 lei. Thank you. Until here. We will take everything one step at a time. From what you discussed or mentioned now and what you stated in the written communication with the Commission, indeed, what you mentioned now is being confirmed, and you reported the contractual price of 10,000. You provided the contract with the 10,000. And in the declaration, you mentioned the amount of 100,000, and you mentioned that actually that amount, 100,000 lei, was paid for the car, which was later reported in the declarations for years 2017 and following years. Please explain what actions did you undertake when you filed declarations for years 2015 and 16? So what action did you take to clarify what was the actual purchase price for that car so that subsequently in the years of for declarations in years 2018-19 to be able to report the correct price? I discussed with my husband who was present at the transaction because I, at the time of the purchase of a vehicle, at the time of negotiating for it, and during the technical inspection of a car at the time of purchase, I was not present. This took place in Chisinau municipality. I did not come with my husband back then. That car was found in one of the markets of Chisinau. It was the only meeting with the seller. I don't know him personally. I did not know him back then. I don't know him today. Based on the discussions I had in 2017 with my husband when I was filling out the declaration of income, he told me that indeed the car is not meeting the technical conditions. I mean, the technical condition of the car was not good. That's why they negotiated to that price. Please, how do you explain the difference between the contractual price, 10,000 lei, and the really paid price of 100,000? Because the difference is extremely large between these two amounts. Why I did not? Why didn't I mention that price? I understood that price. Why didn't you declare the real price since you state that was a true price? In 2016, I did not have time to clarify that issue. My husband was not at home for some time, and I had very limited time to file the declaration. I just couldn't manage with the time available. So I preferred, instead of not declaring the vehicle or declaring it with that small amount, I preferred not to mention it at all than declare a misstated amount, because I was aware that such price could not exist. Next, in the written communication with the Commission, you mentioned that the car's technical condition was not satisfactory. That was a quote from your communication with you. That's why the 100,000 lei amount was paid. To prove that the technical condition was not satisfactory, I submitted documents confirming that a large amount of money were invested in the repair of a car, annex to round 1. Actually, you haven't submitted anything confirming the technical condition of a car at the time of purchase, only the registration certificate, and you didn't provide any proof of investment that would be coming close to 100,000, the purchase price of the car that you declared as real, as well as the money invested in repairing those serious faults of the car. I don't have documents that would prove a payment of 100,000 I don't have, because it has been a long time ago. Again, that was quoted from your messages. Again, you mentioned that in years 2016, 2017, because of those malfunctions, the car was parked at your home address of your family in Breceni town, and the repair works for the vehicle were carried out in the second semester of 2018 in Ukraine. And for that, the amount of 145,875 lei was paid, and that would be an estimated, to estimate it in euros, that would be 7,350 euros. Please confirm or deny that. Yes, I did not provide a document confirming the technical condition of the vehicle at the time of the purchase, because I did not have such a document. No such document was drafted. But do you want to confirm or deny that when your husband paid the 100,000 lei, did not get any receipt from the seller to make sure that he paid the amount, not 10,000 but 100,000? No, because they adopted the sale purchase document in the same day. Yeah, but in the sale purchase document, it's the 10,000 lei. Yes. Well, that's it. Next, also in the written communication with the Commission, you submitted two declarations from two individuals. The first one issued on 28th of July 2024 by citizen VG. We will not give the full names. The declarant mentioned that he held with his car, your husband's Land Rover car, in January 2017 from Yelinets to Brecheni to your residence, and in the spring of 2018, but he does not remember when exactly, transported to a repair shop in Chernivtsi in Ukraine, and for that he was paid 800 lei, not very large amount, and in 2017 he received around 300 lei for some works, probably. The second statement you submitted to the Commission was issued on 28th of October 2024 from Mr. B, stating that during 2015 to 2017, your husband requested several times to fix some malfunctions of the car, which he repaired. The payment was done in cash without issuing a receipt. In January 2017, when it was determined that the malfunctions at that time he could not fix, he recommended to your husband to go to official dealers. Also, in the fourth round of written questions, you mentioned that the car was actually functional in the years 2015-2016. It became non-functional on 27th of January 2017. You mentioned this date several times. So the car stopped operating on 27th of January 2017 until it was brought from Ukraine in the autumn of 2018. That was a quote from your communication. Until that breakdown of 27th of January 2017, where only current repairs were carried out, but since I did not think I would need them, I don't have any proof. Please deny, confirm. Indeed, the car broke down on the 27th of January 2017. Can you tell us what happened on that day? Because you highlighted it repeatedly in your answers. I can, well, say it in a popular way. My husband told me that something about the engine, a technical... So it just stopped. The car wouldn't move because of this engine issue. Therefore, we needed a towing truck to bring it back home, to be able to keep it in our yard, not to leave it on the curb. Because the car just stopped when they were driving to Chisinau, and we couldn't leave it in some community. Indeed, in April 2018, the car... My husband went to the Land Rover Center in Chisinau, and the professionals there calculated the cost for repairing that malfunction, and it was high. At that time, we did not have financial means to repair that malfunction, and for these reasons, the car just was kept in our yard. Over time, we saw that, well, we needed the car for our family, and the second car was purchased 2 months later. A question to clarify, that defect that made the car stop and the car was kept at your place, did that happen as a result of the incident in 27th of January, or it stayed in 2017 to 2017. It broke down when driving on the 27th of January. Yes, but that was 2 years after the purchase. Yes. And the amount that you claimed, 145,875 lei, which is the equivalent of 7,350 euros, was paid for this malfunction. Yes. So we cannot related, or can we relate it to the date of car purchase? We can connect it because we knew from the beginning that we are buying a car with some technical issues, that it's not 100% operational. And the previous owner said that it has an engine issue, and there were some smaller issues that I said in the written rounds that they were fixed, but I didn't have any receipts for that. That was a larger investment for which money was gathered for a longer time. I mean that repair works in Ukraine. So the amount was very large, and obviously the economic operator who repaired our car issued receipt. I thought I sent it to you. Maybe it's a mistake. You did not, so please send them to the commission. Yeah, they were scanned. Maybe it's a technical mistake. I just want to clarify once more. This amount, 145, almost 146,000 lei, was paid for repairing the vehicle as a result of that breakdown in January 2017. Yes. And between the period from purchase and down to that date of a breakdown in January, the vehicle was working, being driven. Yes, it was operational, but since my husband half a year or 6 months a year was spending abroad, it was mostly parked than driving. Yeah, that's another reason, but not because of a defect. No, I just want to say, we knew that the car had technical issues. It was not being used for long distances. It was barely used because we knew that sooner or later that would happen. And for this reason, he was using for very short distances, somewhere in the city, because it was predictable that this thing would happen sooner or later, and it did happen in 2017. Madam Prosecutor, the amount you claim you paid to purchase this vehicle, 100,000, is around 4,650 euros, to make it easier to confirm. While the amount you claim you paid, and you will confirm that by means of the documents you said you have at home, for repairing that big malfunction with the engine, is 7,350 euros. Which means the repairs were more costly than purchasing by around 3,000 euros. Does it make sense to invest in repairs more than in buying the car itself? Well, there was no other solution. The car needed to be repaired, otherwise it would just stay as a technical monument over there. It had to be repaired, and after the repairs we saw, we made a mistake with buying that car, therefore we tried to sell it subsequently after repairing it. Just we did not have another solution but to repair it, to make it working. The prices, the services of economic operators who are repairing, doing such repair works in Moldova were more expensive in Moldova than in Ukraine. And since we are at the border and driving to Chernouts is closer than driving to Chisinau, that we negotiated, and we saw that the price was more convenient in Ukraine for our family. That's why we chose the dealer from Chernivtsi and not in Chisinau, because in Chisinau they wanted 200,000 for those repair works, and that was an exaggerated amount. Even if we disagreed. Could you please explain? Your husband, at the time of the purchase, was he informed by the seller that the vehicle has a technical issue with the engine that could generate a very serious defect? And being aware that repairing a vehicle or repairing such technical elements from a vehicle is extremely costly. I mean, as any man, he knows technical matters related to the car. So what was the thinking behind investing an amount which obviously, after buying it, would generate bigger issues. Again, I was not present during their discussion, but I presume that he did not become aware that the technical issue was that bad. I mean, the negotiated price was very good, and he told me that by buying that vehicle, he took the risk, and that, well, subsequently we saw the engine broke down that badly, and it required a big investment. Next. When collecting information, the Commission was gathering information from authorities, public and private entities, and it was found in the documents obtained that that car was inspected to a periodical or regular technical inspection on 19th of October 2015, so before being bought by your husband. On 25th November 2016, then it was already owned by you, and on 22nd of October 2018. Also, mandatory third-party liability vehicle insurance policies were issued on your name and your husband's names for 1 year period, starting in 2015 in December and up to 2018. So that was done regularly. Also, on 13th of January 2017, your husband, when driving this car, was stopped by the police in Belts municipality, and a fine was issued to him because he did not have an insurance policy. Please confirm or deny this. That is possible. I did not know about this fine, but since the Commission found that, probably yes, you were informed about it in our written communication, yes. How do you explain the discrepancies between the annual declarations for years 2016, 2017, that this car was parked at your home address in Briceni because of serious malfunctions, and the information regarding the insurance policies, the technical inspections, and the police fine after being pulled over by police when your husband was driving, because these aspects actually prove that the car was working. Well, as I said before, I did not say that we didn't use it at all until the 27th of January 2017 when the engine broke. We used that vehicle, obviously, in order not to violate the law, not to have an issue with road police. We obtained the necessary documentation, and that fine, when I found out about it in the question round, I talked to my husband. He told me that yes, when he was sanctioned, when he was fined for not having an insurance policy, on the very same day, to avoid further fines, he purchased an insurance policy, and he obtained a technical inspection of a vehicle. And later on, after a couple of days, I think, maybe 2 weeks after that, the breakdown happened. But the documents were already drafted, insurance policy purchased, and it was kept at home. You have never mentioned in the communication with the Commission what were the defects that needed to be repaired in the period between purchase and 2017 that would determine the smaller purchase price compared to the major repair that you had in 2018, for which you paid more than 7,000 euros. I did not mention because, well, no records were kept, and since I'm far from taking care and handling vehicles, I did not actually follow over the years what defects exactly were being repaired by my husband. The car, well, something was breaking down, it was taken to repair shop. What exactly, it was beyond me. Anyway, I don't understand anything about it, and Even if my husband told me what exactly he repaired, that wouldn't mean a thing to me. Those defects until the 27th of January 2017, I don't mean that they were that big that after repairing them it wouldn't be possible to use the vehicle. No, they allowed using the vehicle after investing in repairs. I will repeat that it was known that there is an engine issue. It just was, so the vehicle was not being used for long distances to avoid happening what happened on January 27. This is what we tried to avoid, but that happened to us. But the vehicle was used slowly in the surroundings, not going far away from home. That's why insurance policies were purchased and the technical inspection was done.
Now, having the Commission collecting information, we've come across on the website of public ads, 999.md, there was an ad regarding the sale of your car dated 13 December 2023, and then it was updated further on the 25th of March 2024, and there were pictures of the car, and the sale price was 11,900 euros. That is about the amount that you have paid for the purchase and for the repairs for the car. Is this right? Yes. So how can you explain this? What is the reasoning for it? 8 years after the purchase, practically 8 years will have passed at that time, and that is the price is 3 times bigger than the purchase price. Maintenance was very expensive for this car, starting with the fuel and having it fixed now and then, the little issues that had to be fixed. The costs were essential compared to another car that we had purchased, and then we compared and we realized how different maintenance was for the second car, for instance, when we compared, the difference was outstanding. So the smallest issues were much more expensive to fix for that car. So that's how a decision was made. Over the years, we've been investing into that car. It's not only about that amount that I can provide substantiation for, and I will provide, if I did not provide the receipts for the expenses from Ukraine, I will provide that later. But in addition to that, other funds were spent too. Now, I can't provide proof of that. We would pay in cash in certain instances, or we would just not always keep all the documentation. But by selling the car, we did not intend to earn more out of it, make a profit, but we wanted to at least recover our investments as a minimum. So that's why the amounts were what they were established. We wanted, following the sale of that car, to at least earn as much as we could, to earn back as much as we could, for instance, to cover the biggest amounts, what we paid for it when we bought it, and the biggest amount, the one that we invested into repairs, so those were the 2 biggest ones. But did you not take into account that it was the wear and tear of the car, the years that it has been in use, and the major overhaul of the engine, which I believe to be serious for any buyer when there's a change as thorough as that regarding the engine, that is. Of that issue, for the engine, there was a guarantee, and when the car was advertised for sale, the guarantee was still valid at that time because there was official services provided. So we have paperwork from the business entity that repaired it, and it provided some guarantees for the engine too, and that was taken into account as well. I wasn't that much involved in establishing the price that we put the car for sale for, so I think I am not that much into cars. I'm only a driver. I'm not that knowledgeable about the technicalities. Though out of discussions we've had at home, that's what I was told by my husband, that he wanted to at least recover what was invested. So the wear and tear, that encompasses other expenses that we have incurred that we cannot prove to the Commission. Thank you. Yet the purchase price was smaller. Why was it like that? What were the factors that influenced it? It was the technical condition of the car. Was it that bad? Since only 2 years later, the car broke down. Well, within these 2 years, we haven't been using the car on a daily basis, not every day. For 6 months out of 12, my husband is outside of Moldova, abroad. And for the other 6 months in a year, and then another 6 months in the next year. So we'd only use the car in extreme cases when there was an extreme need. In the town that we live in, we don't even live far from my workplace at that time when we were staying in Briceni. And the kindergarten that the children were going to was really close to where I was working, and that was only a 5-minute walk. Often it was really not worth it to turn the car on because you'd even get there faster by foot rather than by driving, so there was no need really to use the car. We'd use only the car when the weather was bad outside or if we needed to go to a doctor's. So these were the questions regarding this issue. I am looking at my colleagues if they have any questions to ask.
Does anyone else have questions on the first issue? I do want to clarify the value. I'm still a little unclear on where you got the value of 100,000 lei that you put on the declaration in 2017. Is there any written record for this value?
No.
So where did
No.
it come from? Just out of thin air, or where did it come from?
Nu, din spusele soțului.
It's out of what my husband told me.
Soțul mi-a spus că
My husband told me that the price that he had negotiated with the buyer was 100,000.
care eu am achitat.
And did he tell you anything about that price? Seems very low for what was then a 9-year-old Land Rover. Did he tell you anything about why he was able to get a Land Rover for 100,000 lei? It's a very expensive car, so in our minds, there's an inconsistency between seeing a 9-year-old Land Rover and then hearing that your husband paid 100,000 lei for it only. So I'm struggling to understand if he gave you any other explanation for that low price that he was able to pay for the car.
Eu mă repet, eu
I will reiterate that
nu am cunoștință despre
I don't
mijloace de
know
transport.
about cars.
Eu nu prea, niciodată nu mi-am dat
I never
interesul sau
really
să spunem așa,
felt I
nu
was
înțeleg
interested in this. I
mijloace
don't
de
really
transport.
understand how they
Sunt
work. I
de
don't
glume,
know
ele se
about them.
deosebesc la mine numai după culoare
I
și
can only
mărime.
tell them apart by car,
Eu l-am
by
întrebat
color,
soțul
sorry, and
meu
by size.
la momentul
Take it with a grain of salt.
2015, sincer vă
But
spun, eu am
back
spus,
then, in
am
that year,
în multe dintre ele am
2015,
explicat
in the
ce s-a
rounds of
întâmplat
questions and answers,
În noi
I
familie s-a
tried to
întâmplat
do
o
my best to
situație
explain
așa,
that in
să
our
spunem,
family,
copilul a fost
we had a
diagnosticat cu o
situation. One of
problemă
our children was
de sănătate
diagnosed
severă.
with a severe health
Mie,
issue,
la momentul ăla,
health condition.
nu-mi trebuie multe
And at that
explicații. L-am
moment,
întrebat,
I
spus,
didn't really
asta,
care too much about the explanations.
sincer
I
vă
asked
spun,
him, he
nu
told me that,
tare
and I just took it.
vreau detalii, l-am
And I did
crezut,
not even go into the
să
details.
judec
I did not try to question it more.
așa cum judecam,
Now,
da, la
if
rece,
I
pe
should think
atâția ani,
back,
la momentul
the way
acela nu am
if I
judecat,
thought
deși la 17
in this
exact
way
așa
back then, the way I'm
judecat.
thinking about this matter
L-am
now,
întrebat,
then maybe
mi-a
things would have been
trebuit
different. But I did
să
not have
declar
this way of
această
seeing
sumă
things
în
at that time. And
declarație.
I just
El
asked him.
mi-a
I needed to
spus,
put this down in the
eu l-am
declaration. I've asked for the
crezut
amount.
absolut
He told me that
sigur,
amount. I just
n-am avut
believed him. I
nicio
took it
alegere. Cu atât mai mult, mă repet, noi nu cunoaștem
I took that as the true value. So I did not question it. I don't know who the buyer was. We just met him on that occasion. I don't know that person, so So it just happened. It was a one-day transaction, so to speak. In that one day, they've agreed the transaction, so on that same day, they went to the authorities and they've registered. They purchased, the sale and purchase, and that was it. So we don't know each other. We did not keep in touch. We haven't been in touch over the years, and I never needed to get back to that person. He never called us again. I think that in the meantime, by the way, he too was a prosecutor, so he did not provide, I guess, any contact data, so that we wouldn't be able to find him.
I'm sorry, the person who sold you the car was a prosecutor?
No, he was not a prosecutor. He was a person who my husband met at the market. He was not a prosecutor. I don't know who that was. I don't know who that person was. Well, let's move on to talk about the other car. Also has to do with the first issue of the hearings, the Toyota Auris, purchased again by your husband on the 10th of March 2017. In your 2017 declaration filed on the 19th of April 2018, you reported that the value was over there in that particular column for the value of the asset. You've put down there 10,000 lei, that is about 490 euros. In the 2021 declaration, this car was reported in that same line of the declaration, that same field where you're supposed to provide the value as per the act that certifies origin. You've indicated the amount of 7,730 euros. That is correct. In your answer to the Commission, when you were asked about the difference between these values for the Toyota car in the 2017 and 2021 declaration, you've answered that at the time of the first declaration, I did not have access to the sale and purchase agreement, as my husband was the one who signed the agreement. But because the contract was lost, I couldn't see what amount was there. So I had to report the car, so I just put down a symbolic amount. In the next years, as I was filling out the declaration, I've used that option on the NIA website where you could take over or carry forward the prior year declaration. And I would just make additions to that or changes whenever I had a change in my own situation. So when there was a change, I would reflect that. And because nothing changed about the status of that car, I forgot to make any changes to it, make any updates. And it's only in 2021 when we sold it. To avoid not indicating the real amount, I decided at that point to put in the amount paid for the car. Is that correct? Yes. Madam Fencovschi, when you copy or carry forward the prior year declaration, and in 2017 you purchased this car, at the time that you filed the declaration, you also had the Land Rover car. So you had to add another car at a different price. You couldn't have copied it and moved it forward. You had to add new fields. You couldn't have just taken over the prior declaration. So what did you do in order to establish what was the purchase price for that car on the day that you filed the declaration, given that you also stated that the agreement had been lost? If I may, so the first time the Toyota was reported was for the year 2017, and the declaration was filed on the 19th of April 2018. So from then on, so the 2017 declaration is carried forward, where the Land Rover is declared. That's right, and you had to add another car. I've added the Toyota, and there were changes. That was the change. So that's why when I've indicated it for the first time, that's when we see for the first time the 10,000 lei. But now going back, as I did not have the agreement, the sale and purchase agreement, I put down just a symbolic amount because I thought that I decided to focus on reporting the asset, though I didn't know exactly the price. I mean, I was aware that the price was non-realistic, but I would like to go back to the fact that and to the previous answers that I provided to the Commission that I did not have, that we lost the sale and purchase agreement for that car. And I tried to find it, to get in touch with the business that we bought it from, but that was not possible. Our request was denied because they hadn't kept it. So I put down just that symbolic amount, because on the date that I filed the declaration on, that was already too late. There was a delay, so I did not feel like I had the luxury of asking around my husband what amount was paid. But did you ask the husband? At a later point, after I've already filled in the declaration, I asked him how much he paid. And I know now how much was paid. But it is what it is. It was a mistake made out of haste, and I cannot find and provide any other explanation. I was rushing. In the written communication with the Commission, you've stated that for this car was taken in leasing, and a loan was taken for that, 30,000 lei. And in addition to that, you've also used some of your own savings. That is correct. So when you took out a loan, did you were you not able to make some proper calculations, given that you could have been closer to reality than the symbolic 10,000? I knew about the leasing agreement, and I've reported it for 2017 in that declaration of income. I put the amount 3,900. That's the amount that I put down, and I would like to explain that was the amount that was lent to us, that we borrowed from the financial institution. This amount was taken from a card. Certain financial institutions, to make it more user-friendly, they give you cards. It says what the number of the account is and what amount you're supposed to pay on a monthly basis and some contact data. So that card was used. That's where the 3,900 was taken from when the declaration was being filled on the 19th of April 2018. I was able to do this, and I did, but I have only the same explanations, that on the 19th of April 2018, indeed, I rushed, and the amount was put down just like that, symbolically. I was at the office, and I called my husband, he didn't pick up, and something like that happened. And in 2017, as I was filling it out, there was the Land Rover and the amount for that. And in those fields, under that chapter, I've added the Toyota, and I see that I have to put down a value, so I just did not do quite the right thing, obviously. Well, at the date that you filled out and filed the 2017 declaration in 2018, knowing there was a leasing agreement and there was the 3,000 plus and the 30,000 loan and the savings that you've used for that, couldn't you have made or sum up those numbers to bring a value, to put down a value that was closer to the actual one? But you just went on with the same pattern of using that boilerplate amount, that symbolic amount that often other high-ranking officials were often also using to put down as a value of a car. It's only that it's a mistake. I don't even know how to put it. It's just maybe the attitude was not, I guess, that serious to filling out such declarations. And it doesn't make sense, because given that a leasing agreement to declare that I couldn't, I mean, there was no point. Using a leasing agreement, you can only buy cars. And in that same declaration, there's a leasing agreement, and this car I can explain that it says 10,000 only because I rushed. I didn't give it too much thought. I regard it as something perfunctory. There is no logic in reducing the price because there is the leasing agreement. It's just, let me put it like this, that was quite neglectful of me. In 2021, your husband, on the 14th of July, has sold this car. According to the agreement, he sold it for 100,000 lei. And that agreement was made available to the Commission. Now, in the declaration you filed for 2021, on the 29th of March 2022, you've put down the proceeds out of the sale of that car of 100,000 lei. Concurrently, for that field of assets, you've nevertheless indicated that you had that car, and it's for the first time that we see that value of 7,333 euros. How can you explain this? It's only in 2022, as I was filling out the 2021 declaration, it's only then that I've looked at that declaration in a different way, and I've noticed and I realized that 10,000 was obviously not a realistic one. So that's why I decided to put down the real amount, the actual one. Where does it come from, this 7,330 euros? My husband knew it. It was not a secret. It was not a secret. Later on, 2019, he knew, and now I too. So this amount of 7,330 euros appears for the first time in the declaration for 2021, when you were no longer owners of that car. And you've declared it, nevertheless, as your property and the value of the car. So if your husband was aware of it until that day too, and you knew it too, why did you not report it in the previous years? Well, I'll go back to my previous answer when I said that I was copy-pasting or carrying forward the prior year declarations into the year that I was filling it out for, and I was just making certain updates and additions. In that chapter for vehicles for that year, if there was no change, nothing had happened, then I would just not go back to that to reflect any changes or updates. And it's only 2021. So that's why I've also reported it, or I've reported that as if I had it, because back then I've heard that if I've had it for half a year of that year, I was supposed to report it as something that an asset that we owned and as an asset that we sold, to make it clear that's how it happened. I mean, we had it to sell it. If we sold it, it means we've had it before that. So that's why I reported it like this. And then when I looked up the information again for that car, I saw that a non-realistic amount was there, so I updated it into 7,330. And throughout your time in service, have you been ever provided counseling, some advice, some trainings by the representatives of the NIA? No, I did not have any training. But are you looking at the law? Are you looking at the law at least when you're filing the declarations? I do as much as I can, but it's mostly that we talk to one another, to other co-workers. So you trust more your co-workers than the law? No, I don't trust more my co-workers. I've just explained why I did it. I mean, not why I did it like that, but why it turned out that I had those amounts in my declaration. And then I tried to straighten things out, to address that mistake I made in 2018. So that's why in 2022 I reported the actual price to try to prove that I had no intention whatsoever to keep anything hidden.
Anyone else? Hermontis?
Yes, I have a question regarding the purchase of vehicle Toyota Auris.
Use the microphone, please, or keep it closer because we can't hear you very well. Thank you.
Could you explain, did you participate when the sale purchase contract of the vehicle Toyota Auris was concluded?
No, I did not participate. The procurement took place in Chisinau at a car market. I did not participate. It was a work day, business day, so I was at work on that day.
Did your husband inform you about the price of vehicle when the sale purchase contract was concluded? I'm asking about the vehicle Toyota Auris.
At the time of the procurement, no, but later, yes.
Doamna procuror, o să trecem la subiectul numărul 2.
We'll be moving on to the next issue regarding the procurement of real estate in 2016 for a price that is smaller than the market value and the cadastral value. According to the information that the Commission has gathered, including what you've shared with us in November 2016, you and your family purchased several properties in the town of Briceni on the basis of 2 sale and purchase agreements, as I will be detailing further on. Now, I will not read out the cadastral numbers, but if this matters to you, we can figure that out later. But I think you know what they are. You will realize what I will be speaking about. According to sale and purchase agreement number 6274 of 8 November 2016, the properties in this order, 1/4 of the construction land plot with an area of 0.36 hectares, half a share of the detached house with an area of 163.3 square meters, and 1/4 share of an accessory building of 138 square meters. These were sold by you. You acted as the seller on behalf of the seller C, J, and K-E on the basis of a power of attorney that was notarized, and these were purchased by your husband for the contractual amount of 80,000 lei, that is about 3,720 euros, or about $3,990. According to this agreement, item 3, the inventory price for the sold asset was 131,829 lei. That is about 6,070 euros or $6,570, according to the certificate on the value of the asset of 21 October 2016, issued by the Territorial Cadastral Office of Briceni. This asset was sold for about 2,350 euros, or by this, which was by an amount that was by 2,350 euros less than the value established by the cadastre for taxation purposes. Now, according to the next agreement, the other one that was concluded on the same date, the land plot with an area of 0.1455 hectares, that was also a construction land plot, was sold by you. Again, you were acting on behalf of the sellers CJ and KE, and for that, again, a notarized power of attorney was used, and that was purchased by your husband for the contractual amount of 5,000 lei. That is about 230 euros or $250. According to that same contract, item 3, the cadastral value of this land was 18,532 lei. That is about 854 euros or $923. That is according to the certificate on the value of the asset issued by the Territorial Cadastral Office of Briceni, as in the previous case. This property was sold for about 600, was sold for an amount that was by 624 euros less than the value established by the cadastre for taxation purposes. Can you confirm or deny this? This is true. So this is the land plot that is adjacent to the house, to the land plot where the house is built on with the accessories. It's behind the house. Well, it's close to it, it's near it. Did you enlarge the territory that you had? No, we didn't. I mean, we've bought it and it looks exactly the same. But it's adjacent to, so it's as if the territory that you owned, the land that you owned, was enlarged. In the communication with the Commission, you've actually mentioned that you've started living in this house in 2013 after having agreed this verbally. So there was a verbal agreement between you and the owners of the assets. And later, you and your family have bought this real estate, this property. For these reasons, the sellers allowed you to perform renovations in the toilet in 2013, and that too has played a role in negotiating the price for this property. Can you confirm or deny this? It is true, but in addition to this, there are other factors as well that played a role. Can you tell us what were the factors for both contracts? What were the factors that influenced a price that was much smaller? Well, I've sent yesterday to the Commission. Well, we received that. We received that documentation. So assuming that the Commission has looked at it, I would like to underscore that that house, they used to be government-owned. They were privatized by certain officials. Two of them were owned by 4 owners, and they are on a commonly owned land plot. So the auxiliary constructions and even the right of ownership over certain parts of other buildings, so to speak. That's where the half is from, the 1/4 is from. Every owner had a particular share in some of those buildings that were all located on that land plot. So this house, before we purchased it, the person who was living there was a man who was of an advanced age, and he had a very poor health condition. He had cancer. He was living alone, without wife, without children, and therefore the house was in a very bad condition. It required investments that we've made after 2016, that is after we already had sale and purchase documentation in order. And in addition to the fact that some indoors interior refurbishments were required, that house was not connected to the water supply system. So we only had a water well in the yard. There was no water supply system, as I said. There was no gas supply system either. We've connected it, and the neighbors too, in 2020, and that is proven by the fact that in 2020, that's when we have the first agreement concluded between ourselves and Moldova Gas.
So the heating at that time, until 2020, was based on firewood. It wasn't possible to connect a gas boiler or another heating method, but so only firewood. All of that together led to a decrease, but not decrease, to a negotiation. I wouldn't say those words, but the price was negotiated accordingly. And moreover, the children of that gentleman, they are living in Bender. In the first 3 years, starting 2013, they were coming once a year for Remembrance Day to go to their parents at the cemetery. After 2016, they haven't come again. And they did not have the possibility, and they didn't have other relatives that would take care of the house. I mean, at the situation of 2013. So it was their interest to sell, our interest to buy, because at that time the price was okay for us, and we understood what the conditions were. In 2013, we were renting housing. We had one child and another one on the way, so the apartment that we were renting wouldn't have been enough for us, because it was a one-room apartment, and we understood we need bigger housing, and better, bigger housing would cost more money than we had. Therefore, we accepted the conditions that were obviously make it appropriate with created a toilet, bathroom, and after we paid the sale of the money, we adopted the sale purchase agreement, and the fact that power of attorney was issued is due to the fact that the former owners, or the children of a gentleman, did not have a possibility. Bender is far from Brecheni, and it was hard for them to come, or well, difficult to come, only to draft some documents. On the date you purchased those real estates, 2 separate contracts, the owners were the children of a gentleman, himself, the children of that gentleman. Could you say, how did you negotiate that price, given that in the correspondence with the Commission you mentioned that more serious and expensive repairs you carried out in 2020, 2021, when you invested much more money, and before that you only did some light repairs, but the decrease of a price by more than 624 euros for a land plot neighboring where the house is located, and more than 125 to 150 euros. The difference between the contractual price and the cadastral value. The amounts are not very small for citizens in that region. Is the question about how we negotiated? Yes. Well, it was November 2013. The ladies came to arrange a remembrance meal. I think it was the 40th day after his passing. And so soon they were to come back, and they gave us the key in 2013. And then they came later and issued a power of attorney in our name because we gave them some symbolic amount, around 20,000 as an advance payment, meaning that we have negotiated with them, but just for you to understand me, it was, they don't have other relatives, they have no one to come back to in Briceni. And the fact that they are selling and we are buying worked for both of us. They were interested to sell, they had no one to leave that real estate to be taken care of. So they were ready for a low price because they understood, and they did not have the time to wait and just wait for another buyer. No, but we are talking about selling a real estate. You are not sitting on the market. You publish the ad and you can wait. That negotiation seems to me to be a big disadvantage to the owners. That was the real price. This can be confirmed by the neighbors. By the way, through the neighbors we found out that the daughters wanted to sell the real estate because I did not know them before that. Some acquaintance of mine told me that a gentleman died there and they will sell because they will not be coming back to Briceni. So I went to the neighbors in that common yard and they told me, look, on that date they will be coming, so come on the date and talk to them. I came on that day, I was told, and I talked to them. About the fact that the price is negotiated with us can be confirmed by the co-owners who were present during our negotiation and when sale and purchase contracts were signed as well, because the co-owners were invited to the notary because they have priority right to purchase, but they were invited to the notary and they can confirm that that was the price that we negotiated and it is not decreased. Additionally, the second half of the house that we own is still not sold today, even though it was put on the market much earlier than we purchased our part in 2013. And they are identical in terms of area, identical in terms of conditions in the situation when we purchased in 2013. So that part, second half of the house, in the same condition, no water, no gas, no many other connections to engineering networks. Ms. Fencovschi, when analyzing and comparing, cross-checking information according to open source, a similar real estate detached house with adjoining land with an area of 0.4 hectares and accessory buildings located nearby, I mean in the region where you were living, Marcauț village of Briceni district, in 2016 were put for sale for the amount of $6,000. That was estimated 123,276 lei, almost equal to the cadastral value of a real estate that you purchased. Also with some auxiliary constructions. How do you explain that? I don't know, because here we have a town that's a district center. I don't know what house was valuated there and what were the conditions. This was the sale price. It wasn't the cadastral value, but its value was close to the cadastral value of your real estate. That's why I gave the example of the second half of the house, which is identical as of today. It's identical, and in terms of area and in terms of part, it's identical to what we purchased. The second half of the house is still for sale today for many, many years, and it hasn't been sold yet. This can also be an answer to your previous question, because the girls were not able to negotiate it because the neighbor was put the other half on the market the year before, and it wasn't yet sold. So I don't know why we compare to some other house somewhere when we can compare it to the house. What was the sale price with the neighbors? 10,000 euros, and they can't sell. There have been several buys. I'm living there, and I can tell you. Even today, she can't sell. By the way, ads are published on social media, and you could search for it. I mean, I tried to look for it, but unfortunately, I couldn't find it.
No more questions if you have.
Anyone else have questions on that matter? Then we'll move on to the next.
Okay. Trecem la subiectul numărul 3.
So let's move to issue number 3 and income and expenditure imbalance for 2015. I will announce, I'll let you know when to check the tables where you have some highlighted figures in various colors as a result of a written communication with you during the evaluation. So when analyzing the information about your family's income and expenses, it was found that in 2015 you had the following income, net amount, savings at the beginning of 2015, coming from 2014, according to your bank account statements, 23,515 lei, salary from the prosecutor's office, 86,062 lei, declared income of your husband from the peasant farm in the amount of 20,000 lei, and a revolving loan from a bank contracted in 2012 in an amount of 122,063 lei. Allowance from the National House of Social Insurance, 31,042 lei. Thus, the total amount of income for that year was 282,682 lei. Also, the following expenses were found. Savings at the end of the year, according to the bank statements, 0 lei. Consumption expenditure for population, 105,936 lei. Loan repayment, 75,000 lei contracted from a bank in 2014. So you reimbursed the amount that 21,950 lei. Repayment of a part of an 80,000 lei loan from an individual SV in 2014. So you reimbursed 30,000 lei. Purchase of a Land Rover Discovery car, 100,000 lei. Repayment of a revolving loan contracted from one of the banks that was contracted in 2012 in the amount of 131,617 lei. So the total amount of expenses was 389,503 lei. So if we compare the income in the amount of 282,682 lei and the amount of expenses, 389,503 lei, a negative balance is found in the amount of 106,821 lei. You can see it in the table in red. It is highlighted. In your written communication with the Commission, you disagreed with the amount of consumption expenditure, requesting a recalculation because your husband was working abroad. So he was located in Moldova for a period of 6 months. At the same time, you did not declare in your annual declaration of assets and personal interests for 2015 your husband's activity from entrepreneurial activity carried out abroad, mentioning that according to the legislation in that country, it wasn't required to have to keep accounting records. So he didn't. When asked about your husband's income abroad, you did not provide any information or supporting documents for 2015, not in your declaration of assets and personal interests. No income from abroad was mentioned for the year 2015. Also, in your answer, you mentioned that in Moldova, and I will quote, husband grows vegetables First, we raise animals, poultry, which almost entirely fulfill the family's food needs. Of the purchased agricultural products, we mention only sugar, bread, and other products that we cannot obtain from the mentioned agricultural land. Please confirm or deny that. Yes, that is true. The Commission adjusted the consumption expenses, decreasing it at your request in the context of your husband was spending half a year abroad. So we decreased it by 13,242 lei, which is the amount of consumption expenditure for a person for a month, for half a year. Therefore, after recalculation, the consumption expenditure amounted to 92,694 lei. You can see it in the table highlighted in yellow. Also, in that recalculation that the Commission provided after adjusting the consumption expenditure, the Commission also excluded the amount of 20,000 lei that you declared in your annual declaration of assets for 2015, because that information was not registered by the State Tax Service for the year 2015 as income obtained by the peasant farm. As a result of these recalculations, with recalculation of the consumption expenditure, the amount of income for 2015 was 262,682 lei, and the amount of expenses was 376,261. Comparing the income in the amount of 262,682 and the amount of expenses 376,261, a negative balance was found in the amount of 113,579 lei. You can see it highlighted in green. This recalculation was provided to you by the Commission in the following round of questions, in the fifth one. And the Commission also asked you to estimate the foodstuff that you were raising with your family and you did not need to purchase, so that they wouldn't be included in the calculation of consumption expenditure. Could you please confirm or deny? Yes, that is true. In your answer, you challenged the second recalculation, stating that according to the information on the website of the National Bureau of Statistics, the amount of the subsistence minimum amount calculated based on a regulation approved by the government of Moldova was on the average per person 1,956, and with some calculation for the period where your husband was in Moldova for the number of people, and that amount was different from what the Commission claimed. So I would like to inform you that you claimed other calculation for minimum subsistence expenses, where the Commission is using consumption expenditure calculated based on a different regulation, and it varies from urban or rural area, number of people, including children or grown-up, categories of expenses, and so on. You can find this regulation on the website of the National Bureau of Statistics as well. You also mentioned in your answer to the fifth round of questions that the estimation that you provided for the foodstuff that you are growing or producing individually with your family would be of around 10,000 or 15,000 out of the calculated amount. As a result of your request to recalculate the consumption expenditure by 15,000, the Commission adjusted the expenses, which, depending on the amount of expenses, if we deduct 10,000, then it's 82,694. If we deduct 15,000 lei, then we have the amount 77,694. So we made this parallel calculation. We accepted your request. So after recalculation, the amount of income stayed the same, 262,682, while the amount of expenses was 366,261. If we reduce it by, if we subtract 10,000, or the 361,261 if we subtract 15,000. So we have these two amounts in parallel. You can see it in the table in yellow, highlighted in yellow. The difference between income and expenses, depending on how much we subtract, 10 or 15,000 for 2015, was 103,579, or in the second case, it is 98,573. Therefore, again, we see a discrepancy between income and expenses. The expenses exceed your income. Please confirm if you accept or challenge any of the information, of this information mentioned in yellow in the table. I disagree only with the amount that was subtracted in the income declared by my husband. In the end, the Commission does not take into account the 20,000. I understand why, because it wasn't declared to the tax authority, but I'm going back to my previous answers. I have never been involved in the management of a household, of a farm. You did not, but your husband is the manager of that farm. And when you fill out the declarations, do you rely only on what he tells you, or do you confirm it by any document? Well, when I started to file declarations officially to the state tax service, I looked into documents, but before that I was asking him verbally, he was answering me verbally. So that's what happened in 2015. When I asked him, what should I mention when I was filling out my declaration, I asked him, what amount should I put under the income obtained from that household farm? He told me 20,000, that's what I reported. Why? Well, I mentioned I'd never handled that farm. For you to understand me correctly, I was never part of drafting any documents or related to it. This is my husband's work, and my part of work is different. I just asked him because I needed it to fill out the declaration. He told me, no, I asked him, why didn't you declare it back then, if you had that income? Because now I have to explain why it hasn't been. He told me that someone told him back then that he didn't have to report, and these things are being confirmed. Like 1 year he was filing it, another year he's not filing, 3 years not filing, and again. So only in the last 5 or 6 years, the annual declaration is filed regardless of income and expenses. Even if the expenses are bigger, we concluded that the declaration has to be filled out every year, regardless of whether they make an income or not. And that's how it is explained that subsequently you can see the annual declarations regardless of negative or positive balance. So I'm still keeping to my position. That income existed. Even though I understand that it is not changing significantly, that discrepancy does not eliminate it, but I would want it to be taken into account by the Commission, that amount of 20,000, even though he did not declare it to the tax authority. Thank you. Next question. Please explain, how do you ensure the veracity, the truthfulness of the information you include into the annual declarations of assets and interest, especially this amount of income, given that the declarant is the one who is liable for the accuracy and comprehensiveness of the data. And the time when my husband started to file annually his returns, I think last year he signed it electronically, I asked a copy of the declaration so I can take a look and take the precise figure, not to make a mistake. But in 2015, well, I only asked him, I did not ask Dr. Could you please inform us, do you have any confirmation documents from that peasant farm that it had some income in 2015? No, I can't, because that has been a long time ago. Thank you very much.
I have a couple questions. You mentioned several times, both with regards to the Land Rover and then again that your husband works abroad for about 6 months a year. What does your husband do? What's his profession?
He's selling on the market, selling multi-annual or perennial plants on the market. I don't know if the Commission received it, but I sent the certificate for the registration of the company that my husband opened in 2011. Also, yesterday, I sent the Commission I needed more time, but I found my husband's passport, where you can see the stamps going in and out the country in 2015. I mean, you can see when he was leaving Moldova and when he was coming back to Moldova. And that's how I wanted to confirm that he was indeed abroad working. And I'm not lying when I'm saying that he had no possibility to obtain income and import it to Moldova.
So when he works abroad, where does he work?
In Novgorod city?
In Russia.
Yes.
And what does he do there? I'm still trying to understand what he does in Novgorod.
He's growing and selling multi-annual plants. That's why he's going there in spring and stays until autumn.
And so what kind of income does he make in Novgorod?
It varies depending on the market situation. I'm going to my answer where I said that his form of company's organization does not require accounting records. That's why I can't provide any reports or notes, especially not from back in 2015, that would confirm his income, the income that he earned in the Russian Federation. But in 2015, well, he was working officially because the company he opened and started in the Russian Federation was started in 2011, and the company is still active. It stopped only during COVID in 2020 and 2021 when my husband did not go to the Russian Federation because it wasn't possible to travel. It wasn't allowed to leave the country and come into the country.
So if your husband goes to Russia for 6 months to work, he must be getting some income from his efforts there. So how much income does he get? Approximately.
It depends from a year to another. There are years when he comes with more income. In some years, comes with no income. In 2015, I don't know, to estimate maybe 5,000-7,000 per year, in half a year. And him traveling abroad is made in 2 rounds, exactly as it was done in 2015. He's going there in spring. Then in summertime, for 1-2 weeks, at most 1 month, he comes back home. And then in late July, early August, he goes back to Russia and comes back in October. When the weather becomes cold in the Russian Federation and the sale of these products is not possible anymore.
You said 5,000 to 7,000. What currency is that? Euros, dollars?
Euros, dollars. The currency that he brings is different from a year to another.
Have you reported that income on your declaration forms in the relevant years?
No, I did not declare it in 2015, but I declared it subsequently.
Thank you. Let me see if there's any other questions on this issue. Virginia?
One more clarification question. In the written rounds, you were asked in several rounds about your husband's income abroad, obtained in the period between 2012 and 2016 or 17. until you started to declare it, and in none of those rounds you provided any amount, at least approximate amount, as an income that your husband would have brought into the country, always saying that it was a longer time ago, that you didn't remember, and you don't have any amounts to include in the tables that we sent to you. Is that true? Yes, I provided such an answer to the Commission. Thank you. Now we will move to the last issue. Number 4. Failure to declare real estate in the annual declarations of assets and personal interests held at the date of filing the annual declaration, and failure to declare the value of real estate in the annual declarations for years 2012 to 2022. While evaluating your candidacy, the Commission analyzed all available declarations. That means declarations for the years 2012 to 2022, including the declaration for 2023. But for the evaluation period, we included 2012 to 2022. We cross-checked that information with the information from information system held by public authorities and institutions. So as a result of, or based on information from e-Cadastre system, you, through legal means, obtained ownership of several real estate items during that person. So sale or purchase, donation, also authenticating the right of ownership, and also based on court decisions. So, as a result of cross-checking information in the annual declarations and the information in the e-Cadastre, it was found that you did not declare several real estates owned by you and your spouse. So, out of 28 real estates owned during the years 2012 to 2023. So, at the date of filing the declarations, the following real estates were not reported.
Starting with 2012, that is the 2012 annual declaration. There, you did not declare an apartment, number 25, with an area of 53 square meters in the town of Dondusheni, that you've acquired on the basis of a sale and purchase agreement of 26 February 2001. Next is the land plot for construction with an area of 0.02 hectares in the town of Bricheni, that you've obtained on the basis of a court decision number 2786 of the 22nd of July 2010. The third asset is a construction land plot with an area of 0.0791 hectares, again in the town of Bricheni, obtained on the basis of sale and purchase agreement number 8052 of the 2nd of November 2007. And the land plot for construction with an area of 0.0793 hectares, again at the town of Bricheni, registered on the basis of the landowner title issued on the 10th of October 2007. Then farmlands with the area of 1.7151 hectares, and that was obtained under donation agreement number 6823 of the 13th of August 2007 and number 7766 of the 9th of August 2007. In 2014, these properties were united under one single cadastral number. They were joined, and farmland plot with an area of 0.8575 hectares in the village of Tsaul, Dondusheni district, on the basis of the landowner title of 2000, December the 2nd. In your answers provided to the Commission regarding these properties, you have stated that you raised this with the Human Resources Department when you were filling in and filing your 2012 declaration, that you were told that the assets acquired until 2012 and reported in the declarations for the previous years, that they didn't have to be declared, didn't have to be reported in the annual declaration for the respective year. And out of that, or on the basis of that, you did not report that property that you acquired in your 2012 declaration. Can you confirm or deny this? That is correct. That's what I've written, and that's what I've answered. Now, Madam Fencovschi, in 2013, when you filed the 2012 declaration, you already had an experience in the legal field of more than 10 years, more or less. And before filling in the annual declaration, both old ones under Law 1264 and the new ones, have you been looking the information up in the law? Would you seek someone's advice on how to fill them out? At that time, we would pay attention to the guidance from the Human Resources Department. We would follow their advice, and that's how things would work out, because we filled out declarations like that for the previous year too. So I remember well the discussions we used to have. We would be told that you need to only report the assets acquired in the year that you're reporting on, because you have already reported the previous assets. So that's why for 2012 I've reported only what I've acquired, what I've obtained in 2012. When in 2013 I filed my declaration for 2012, I've only reported those assets that have been obtained in 2012, have been acquired in 2012, without repeating again the assets I had already declared in the past, because I did report them in the older declarations, but I did not copy-paste them again. Later, it turns out that was the wrong approach, so that's why from 2014 onwards you can see them all, regardless of the year in which the right of ownership was obtained. But did you look at the law when you filed the declaration? Not at that time. I mean, we were having some discussions at the office, or the boss would call us and would say, look, I talked to the Human Resources Department and they told us to do this like this, so we would not call separately. It was more of a centralized approach. In your 2019 declaration, you did not declare ownership right over a farmland with an area of 1.715 hectares. Again, this one too is in Dondusheni, the village of Tsaul, and that you obtained under the sale and purchase agreement number 2333 of the 22nd of March 2019. Can you confirm or deny this? I cannot confirm this. Now, with regards to all of the assets that we are mentioning now at the hearing, you've already been asked about them during the questions and answers rounds. I just want to make sure that I got this right. The one that you've paid 20,000 lei for. I've reported it the second year after it was purchased. So it was purchased in 2019, but I've reported it in the next year for 2019. You've purchased it on the 22nd of March 2019, and you filed the declaration later than the date of the agreement. According to the law, you are supposed to report the asset that you have as at the date that you are filing your declaration of assets and personal interests. And so it was mandatory for you to report it. Let me have a look, if I may. It is dated 22nd of March 2019. That's the date of the agreement. So I've reported it in the 2020 declaration. But what about the 2019 one? The declaration for 2019. It was not reported because when I was filling in the 2019 declaration, I was doing that for 2018. Yes, but you are supposed to. I mean, you're reporting for the previous year, not what you have at that moment in time, but for the previous year. So I had bought it in March 2019, and I've reported it in 2020 when I filled out and filed my 2019 declaration. Understood. In the annual declaration for 2022, you did not report the following assets. 2 orchard lots, each of them with an area of 0.06 hectares, both of them in the village of Corbu, the district of Dondusheni. Both of them were acquired under sale and purchase agreement of the 19th of December 2022. They were purchased by the peasant farm owned by your husband. None of these assets was reported in the 2012 declaration. although they were purchased before the date of filing the declaration, before the 30th of March, which was the 30th of March 2023, and they were only reported in the 2023 annual declaration. Now, as for the contractual price for these assets, that was 150,000 lei. The properties, again, in the 2022 declaration. So the properties in the village of Corbu, Dondușeni district, obtained under sale and purchase agreement of that same date. On the 19th of December 2022, they were purchased by your husband's peasant farm, although as in the first case, they were bought before the date on which the annual declaration was reported, and they were only declared in the later 2023 declaration. And specifically, the assets are a farmland with a surface with an area of 0.935 hectares and a construction with an area of 160 square meters, a warehouse facility with an area of 42.4 square meters, and an auxiliary construction with an area of 12.9 square meters. And according to the same purchase agreement, the contractual price for these assets was 250,000 lei. Can you confirm or deny this? With regards to the failure to report this, with regards to the information I just read out, that is all correct. Now, in your answers to the Commission, because this was raised with you, you were asked about the failure to report these assets that you've obtained in 2022 on the basis of those aforementioned agreements. You've stated that the procurements, as per the agreements, that they were entered into and concluded by your husband without you knowing about those procurements, and therefore, on the date you've reported, you filed your declaration, you were not aware of those. In 2024, when you filed the 2023 declaration, you've asked your husband about the income, the proceeds, the income of that peasant farm, and that's how you came to find out about the assets that had been purchased. So is it correct that you've only found out about them a bit more than a year later? You could put it like that, and I've explained in the Q&As that the discussion about these assets, well, we've had such a discussion at home in our family. We did not reach consensus with regards to the procurement of those assets. Consensus between you and your husband, that is. That is correct. We did not reach consensus. We could not agree. So following the discussion, it felt like I had been heard that I disagreed with the procurement of those assets. We've had a discussion about our shortage of funds and that it would be in a situation to take a loan, and I was against taking a loan out, rather not so much minding the assets, but minding taking the loan. So I thought that I had been understood. And that was all I thought. I said I disagreed, and I provided my substantiation of that. But indeed, a year later, when I've asked for that information for the declaration, and in the declaration there was the expenses, the loan, the bank statements, I needed to have a look at that to be able to report in the declaration. I saw that there was a loan, that there has been a loan taken out. So there was some delays in the payments, and I was the guarantor, and because of that I was called from the bank because my husband hadn't paid the installment he was due, and that's how I came to find out about the loan. So when I filled out the declarations, I saw that they were not there, so I said, thank you, but let's at least report this. What is done is done. So that's why a couple of days after the declaration was filed, the 2023 declaration, that is at the end of March, I think the 30th or the 31st, I can't remember. And at some point, some of the first days, I think, that's when we filed the paperwork for registering all the ownership rights. I mean, the contract, those agreements were registered with the cadastral authority. So that's how things turned out. Around this failure to declare for 2022, that's how things worked out. Now, the total amount of these two agreements, 150, and the other one, 400,000 in total. So you now stated that a loan was taken out and that you were the guarantor. Do you have that agreement? Did you sign that agreement? I did not sign that agreement. Well, because it is a small town, the staff of the bank, well, they know us. I and my husband, we hail from there. The peasant farm is related to a branch of the bank from Dondușeni. It's a small town. People know each other in the face. So the bank employee, seeing that there is an emergency, that there's a delay, so to speak, he called me. He told me about that issue because my husband was abroad. He wouldn't pick up the phone. So I was the one who was called, and I was told that there is a red light, so to speak, and that some amount was due to pay back a loan that was taken out. But if I had signed that I agreed to be the guarantor, then I would have known about the agreement, but I didn't know. I did not sign that agreement. In December, when the procurement was carried out for both contracts, that is, you were not aware of the fact that a loan was taken? You did not know that your husband has taken a loan out? Did you not talk about it? I did not know about it, but we did talk about it. That was specifically the reason for our discussions, because I was against the loan, and that procurement was expected to be performed using a loan, by taking out a loan to be able to buy that. And the owner had moved to Romania, and the owner was supposed to come all the way from Romania for that procurement, and we've had a discussion about this in our family. And I said I was against the loan, I was sick of loans. That's what I said. So I was against us taking out a loan. That purchase and that loan, these have all been formalized in Dondușeni, which is also the branch providing services to the peasant farm. I was in Briceni, so therefore I had no knowledge of it. I didn't know, and there was no way for me at that time in December. I mean, he did things how he saw fit. He's an adult, and he did what he wanted to do. Next, in those declarations for 2012 to 2022 through 2022, with a few exceptions for certain assets that you've declared, that you've reported the amount, the contractual amount or the cadastral amount, depending on the different declarations. You failed, though, to declare the following properties. I will not read them out by the cadastral number. I will just say how many of them. So in the annual declaration for 2012, only 2 properties were reported, real estate property, that is. You have the value, but not the assets that I've mentioned earlier for 2012. In the annual declaration for 2013, out of the 15 real estate assets that you've reported, for none of them did you report the value. There's no value for the 14 assets reported in the 2014 declaration, not a value for the 14 assets reported in the 2015 declaration. Of the 18 assets you've reported in your 2016 declaration, you've only mentioned for every separate asset in that where you're supposed to put down the value. You've stated no value. And for the 20 assets in the 2017 declaration, there is no value. There is no value for the 20 assets you've reported in your 2018 declaration, and there is no value reported for the 20 assets reported for the 2019 declaration. No value again was reported for the 20 assets reported in your 2020 annual declaration. You've put down 0 for all of them, for each and every one of them. And in the corrected 2021 declaration that you have submitted on the 11th of April 2022, you have only put down the value of 2 assets out of 21 assets that were reported. For the rest, you've only put down 0. In the annual declaration for 2022, you've reported 23 assets, and you've again put down the value for 2 of them only, and you gave a 0 for all the rest. Do you confirm or deny this? This is correct. I confirm it. Why did you not report the value of these assets? Let's say that in the older templates of the declarations, as per the older law, the declaration of income, as it used to be called, the lawmaker expected, and that's what it's like, what is put there is the collected income, not the value of the asset. But we're speaking about immovable property when we say asset in both the old one and the old template, the new template, where you were supposed to report the movable, immovable assets. You were supposed to put down the value as per the cadastral assessment or appraisal or the contractual, the agreement, the amount in the agreement starting with 2021. For immovable assets, the cadastral value was supposed to be reported until the law was amended, that is 2021. Thank you. Later, some amendments were done with regards to the contents. The requirements was amended, so we were supposed to provide the market value and the actual value of the asset. Now, I wasn't very sure about that. I didn't have that much certainty about those values. Back then, they were saying that initially, the first time we've reported, we didn't know what value we should put down. Is it the price that is in the sale and purchase agreement that we should report? Or was it something else? Somebody was saying that they might be reduced and nobody will believe that, or underpriced, or we didn't know what was the right way to go as regards the value of assets. Now, with regards to the market value of the assets, we were guided, or we were told that there was going to be, let me put it like that. So we need to look it up on the social media and pay attention to similar ads to make sure that what we are reporting is similar to the market value. Well, I admit that the value of the assets isn't there, but I would like to also tell the Commission that I did not pursue any interest to hide anything or to avoid reporting. For all the assets, I just thought that if I had no certainty, I was not sure about the amounts I would report, then I thought that I should only have the assets declared every time, the ones that I owned, so that they're not regarded as hidden, or like I was trying to avoid filing the declarations. Though yes, I do admit that the values were not there. Understood. Thank you. Now, out of the documentation that you shared with us, I mean, the one with regards to your ownership of our assets. You have shared with us a lot of agreements showing that you've purchased assets and agreements that you participated in as well, speaking of the sale and purchase one specifically. You did participate in the notary, in those procedures at the notary when the agreements were being notarized, so you know that the notary is reading out loud everything that is in the agreement. The notary usually explains to the parties the contents of the agreements, if there's anything they don't understand, in the donation agreement, in the sale and purchase agreement, in other categories of agreements, in other documentation that certify ownership or that transfer ownership right. Those contain cadastral values as well. And with regards to the assets that you did not report, but for which you had agreements, there was cadastral value in the agreement. For instance, the 2016 assets, you have these agreements at home because you've shared that with us. Did you ever look at those agreements to see what the cadastral value was for you to include in the declarations? I think that's the explanation, that I did not look it up in the agreements, because all of our documentation that does not require being used on a daily basis, we keep that in our Dondusheni apartment, because in Bricheni we don't have that much room. So every time I was about to file the declaration, to fill it in and file it, I never had the contracts, the agreements around. Bricheni and Dondusheni are 70 kilometers away. So, as a rule, I wouldn't have the time to even go to Dondusheni and be back with those agreements. So this kept happening year over year. And I would like to go back to what I've said, that I was just taking over the prior year declaration. If you look at that, you will see that 1 year and then to the next to the other, it's practically the same. It was just that I would make some updates if there was any change in my situation. It wasn't a mission on my part, but I did not have the goal to avoid reporting or to hide certain assets or not to disclose them, though I do admit that this is not entirely in line with the requirements of the regulation. Thank you. No more questions from me. Do the colleagues have any questions regarding this subject.
I just want to go back to this loan that was mentioned. I want to clarify that. You referred to a loan in Dondusheni. What
Da.
you mentioned they called you in December. What year was that?
Nu, m-a sunat
No, I was called in summer 2023, when my husband was abroad.
And what bank was that?
Agroincombank, de unde s-a luat creditul.
Agroincombank, where the loan was taken from. There was a branch in Dondusheni, and that is also the branch that is providing banking services to the peasant farm. They have an account with that Dondusheni branch of the bank. And my husband has left some funds on the account so that on a monthly basis, when he was supposed to pay anything, like it's an automatic withdrawal of the funds, the bank takes the money that are due from the account. But at the time, the money had been all used, it appears, and that's why I was given a phone call, and it's just we know each other. As I said, those are small towns, we know each other. So they knew my phone number. I have family. My brother also lives there, so he too is using the services of that bank. So that's how word got out.
Was that loan declared on your declarations?
Da.
Yes.
Okay. Does anyone else have any questions? Virginia, is there any other matter? Okay. So that brings us to the close of the hearing. I do want to make one clarification. There were a few references to you sending some more documents. We've been inquiring since July for you to send things and answer. So I want to just confirm so you understand, if we have doubts, it's your responsibility to mitigate our doubts, and this has been going on for a long time, this investigation. So if you are planning to send us anything else, it needs to be done within the next 3 days. We need to have that in hand by Friday. And that's not our responsibility to get that from you at this point. It's your responsibility to get it to us. So I just want to make clear that any other documents, they need to come this week. Is that understood?
Da, aici s-a primit o eroare.
Yes, it's only that there was some error with me sharing the documentation. I think it happened when the Secretariat, by the way, can confirm that out of the agreements that I've sent, some of them reached the Commission and some of them didn't. Some pages reached the Commission, some didn't. So then the Secretariat asked for the pages that were missing, and I think that's how I overlooked something. I have it, so I'll do my best to send it today.
Your responsibility to get it to us.
Da.
I just want to make
Da.
that
Da.
clear. Okay. So at this point, we'll give you the floor to make any closing statement that you would like to make.
Esteemed members of the Commission, I would like to thank you for having listened to me. I hope that I tried my best to be as honest as I could, answering all questions. I would like to ask the Commission to consider that although here and there I might not have filled in all the documentation I was the way that I was supposed to, in line with the rules. That might have been the case, but I tried my best to report all the assets, at least quantitatively. I tried to report all my assets, so I think that is proof of the fact that I did not try to hide anything away. And same as with the car, the Toyota Auris. Although I understand what this looks like, in somebody else's eyes. I did not have any intention to cover anything up, and that is proven also by the fact that in 2022 I've reported it. When unfortunately certain things happened too late, but I've clarified things out, and I've made certain amendment changes to the declarations where I was supposed to. And with that car, things turned out like that. You see, it's hard for me to know to now find any explanation that is stronger than anything that I've said so far. But the fact that I had no intention to hide anything, that is also proven by the fact that I've reported leasing agreement. So there this cannot be seen in any way that I was not trying to hide anything. And I hope that the Commission can also consider the fact that my husband has indeed been working abroad, and that he's been doing this for more than 20 years. I've already sent to the Commission a copy of his passport and a certificate showing the incorporation of his enterprise where he is working officially there, and the documentation from the Russian Federation dated with the year 2024. So that is valid, that is up-to-date information, not something that is old from many years ago. And ultimately, I would like to tell my family members that I am grateful to them. They were there for me. This was a process that was psychologically difficult, emotional. Unfortunately, I realized too, in my mind, I realized that certain public institutions are not doing quite a good job in terms of their duty, starting with the answers that I was supposed to clarify, talking to the border police and financial institutions. I would like to thank those who did not say no to me, to those who helped me with making it possible for me to share true information with the Commission, and I mean third parties that are not family members who supported me in this regard. And thank you for your attention.
And the Commission thanks you for your participation in the evaluation process and at the hearing today. We will now deliberate on this matter and reach a decision as soon as possible. And so I declare the hearing to be closed. Thank you.